Hey folks, Attorney Sharif Selmi. I'm coming to you live this evening, and I want to touch on some current relevant events taking place and some data that we've been mulling over and considering and looking at, and also addressing the kind of misconceptions that persist, particularly as it relates to the employment-based categories. So I went ahead and did a bit of a breakdown of who's actually winning EB1A and NIW cases by country. And this tells us where approvals are concentrated and how applicants can learn from these trends. So total EB1A approvals in Q2 of 2025. Q2 of 2025. This is the latest and most recent data out there, demonstrates that a total of 3,429 EB1A cases were approved, a little over 1,000 per month for the Q2 of 2025. National interest waiver approvals are almost double, with 6,623. As expected, India and China dominate these categories. India in particular takes about 28% of all EB1A approvals. And combined, India and China have over half of the global EB1A approvals. This shows how competitive the EB1A space is for Indian talent, especially in STEM and artificial intelligence related professions. Now, one thing that I would note, though, is USCIS does not provide data of how many of the total applicants are actually from India or China. We only know how many of the approved applicants are from India and China. So while India makes up 28% of all approved petitions, we don't really know what the specific country approval rate is for India or China, for that matter. So that's something to be take note of. Now, we do see that ultimately, Indian nationals are punching above their weight in the EB1A approvals. But remember, again, approvals do not equal filing. So, India is also by far the largest applicant pool. Now, I've extrapolated some sort of supplemental data on this issue, and I find that the approval rate of Indian nationals for EB1A is actually lower than the general average. So if you take all of the approval rating of EB1A writ large, we find that it is somewhere around between 70 and 74% approval rating. And by the way, I think this is a critical information. The approval rating for EB1A in particular has not changed dramatically from 2024 to 2025. So if we look at Q2 2024 and we look at Q2 2025, the numbers are about the same. There's not really any difference in the numbers as it relates to approval for EB1. So I think the kind of rhetoric that we hear in the public domain is not really translating into actual statistics. And we see that in our own practice. I mean, we've had several approvals come across just this week, and we're seeing, ultimately consistent adjudication with some sort of, I think, few inconsistencies that probably relate more to a lack of familiarity among the adjudicators with the content being discussed and, requests for additional evidence than we actually see in terms of, increase in denial rate as it relates to EB1A. Now, I think national interest waiver, it's fair to say, is a different story. There has been a noticeable decline in approval rating for national interest waiver. It's actually gone down close to 20%. So although there are still, lots of approvals coming across, and, it does kind of reflect the strong demand for advanced STEM talent. There is still a much less, a reduced amount of approvals for, national interest waiver as it relates to 2024. So that's something we're going to keep our eye on and make sure that we are addressing. Now, I think that part of the national interest waiver issue relates to the more conservative view of proposed endeavor. And in our practice, we have taken a different approach as it relates to proposed endeavor, just to make sure that the specificity of the proposed endeavor being claimed is properly addressed, so that you don't have that kind of backlash that's occurring across the board in terms of a reduced approval rate for national interest waiver. Again, we are seeing that, being part of the 28% of those all EB1A approvals coming for India, is a great opportunity. It means that, if you are looking to apply for EB1A, we are still seeing robust approvals for, Indians, particularly in AI and STEM related professions. I think we could safely say there are reasonably high approval odds if you frame your extraordinary contributions properly. So, positioning the evidence and specificity are going to be the most important aspects in these successful cases. So, thinking about that Indian approvals account for nearly 1 in 3 EB1A approvals. And if you're Indian born and working in STEM or AI, there are basically no excuses at this point. You need to really, think about checking with us for a consultation, checking out silmilaw.com, so we can look at your profile and make a compelling case for you to apply in the EB1A category. So, that is really, really important, because I think that, if we look at it, like, again, going to the year-to-year comparison numbers for EB1A, it's actually interesting because in fiscal year 2024, second quarter, so Q2 of 2024, we had 603 Indian national approvals for EB1A out of a total of 3,112 approvals. That means at that time, Indian nationals made up 19.4% of all approvals, right? 2025, we have 967 approvals out of 3,429 applicants. So basically you have an increase of almost 35% in approvals for Indian nationals in the EB1A category out of a total of 3,429. So they made up, like I mentioned, 28% of all approvals. So that's really interesting data. I think this is something we should, pay close attention to. So India's share has jumped significantly from 19% of approvals to 28% of approvals from Q2 FY24 to Q2 FY25. So that is something that is actually pretty interesting for us to consider, and that the EB1A pathway is proving especially valuable for Indian applicants, while national interest waiver remains steady, but maybe more competitive in terms of, where that sort of, approval trend is headed. Now, when we're thinking about practical guidance for applicants, I've said it again, I've said it before, and I'll say it again. Define your field of endeavor. USCIS is scrutinizing general claims. For example, if one is trying to seek an EB1A and their claim is, I am an AI expert, instead of framing it as, an artificial intelligence, expert or developer for example, neural imaging diagnostics or AI-driven supply chain automation, then you're doing yourself a disfavor. The precision that you give in your EB1A framework is going to set you apart. This is very, very important to consider. So build the evidence around your niche. Publications, citations, and patents are not the only way to build evidence. You need to think about what is the most important work-related contributions that I've been involved in, and how do they impact the actual way in which I'm going to get a victory in my case. Super, super important. So again, EB1A is best for those with clear high-level recognition, but you need to consider what that looks like in terms of developing the evidence. I mean, if you think about it, those of you who are Indian nationals and either you have a priority date that's close to like EB2 being current, it's, in my view, worth considering a dual filing to maximize flexibility. So that means that you wouldn't just file for EB1A, but you might also benefit heavily from filing a national interest waiver, because in the current economic situation that we have, and I'm just going to see if I'm capable of sharing my screen here, which I'm not entirely, confident in, but we'll give it a whirl. We find that in the current environment in particular, there's going to be slower hiring. There's going to be there's our buddy right here. There's going to be rising labor pressures. So slower hiring, rising prices, worry consumers. Fed points to sluggish economy, right? Economic uncertainty and tariffs are negative factors. So businesses were hesitant to hire because of weaker sales and an uncertainty tied to U.S. trade wars. So this kind of thing is going to put a lot of pressure on folks who are, seeking to, change jobs, or might run into pressure with your current employer. That's why if you are a H-1B holder and you're dependent on your employer for your actual status, it's probably really, really important strategically that you take matters into your own hands and not really depend. I think actually the economic factors are probably going to play a bigger role than the immigration challenges as it relates to the overall situation. So I would say, for those of you who are super talented, 450, 500,000 salary plus, I don't think that, particularly if you're an AI related professional, if you're not doing EB1A, contact us. We'll get you started and we'll get you guided and put it together with approval. That's something I could definitely deliver for you. Now, if you are sort of not quite in that stratosphere, then, it's really important to have that NIW as a backup if you have a priority date that is close to being current, particularly if you've had a job change, because if your new employer is filing the perm, that could take, a lot of time and sort of, impact your ability to get approved. So that's going to be something, you'd hate, for example, if your date finally becomes current after, waiting 20 years and you happen to change jobs. Maybe your, previous employer filed, or you change jobs after getting a previous I-140 and it's within 180 days. The AC-21 rules won't necessarily protect you in that case. So, in many situations where people have changed jobs, they will run into a lot of issues as it relates to, adjustment of status. So that's why I think a national interest waiver is particularly important for these folks. Thinking about, again, why it's so important to be specific, right? Be specific about what you're doing as it relates to your field of endeavor. It's going to be more important than ever. One other thing I wanted to go over with you all, just so that everybody's up to date, are the current events that are taking place. There are a number of things that are quite important first of all, which this is kind of expected, but I'm going to again add to the stage that we have news that EB2 green cards are going to be halted until September 30th. Obviously, this does impact Indian applicants the most because they're the ones that are facing the longest backlogs. Now, you have to understand, though, this is expected because September is the last month of the current fiscal year. So the number of new visas gets loaded in October 1st. So by October 1st, you'll start to see some relief in that department, and you won't really have to worry about this situation. But it's really, really important. Those of you who are, currently having your dates current or almost current, know that nothing's going to happen in the month of September. USCIS has reached its cap on EB2 for FY25. So no new EB2 green card issuances will occur until the new fiscal year begins on October 1st, 2025. So the latest visa bulletin, and this is September 2025, shows second category India as January 1st, 2013. Third category is May 22nd, 2013. Now, this 2013 date will not be honored in the month of September because they've already hit their quotas. So that's something that's going to be, noteworthy. The other issue that is of particular concern to, I think, a lot of folks out there is that the U.S. and USCIS have really tightened their family immigration policies with stricter vetting and interview rules. As of August 1st, USCIS increased vetting and interview requirements for family-based immigration petitions. This policy, according to USCIS, aims to curb fraud and verify, supposed claimed relationships. Now, what this is really about is slowing down immigration. There is a, you could call it a segment of the right wing in the U.S. that is clearly anti-immigrant. They want to stop immigration, reduce immigration to the extent that they possibly can. And tougher scrutiny will be applied to, U.S. citizens. So if you're a U.S. citizen and you happen to, fall in love with somebody from another country, tough for you, because now instead of having a reasonable immigration process to reunite your family, they're going to slow walk the process. It's going to take quite a while, and expectations of what this all is going to entail might need to be reset. You might need to think about the different kinds of approaches that you want to take as it relates to developing your immigration strategy, and definitely consult with an attorney. We're happy to talk to folks because this heightened scrutiny is going to impact. So USCIS stated in its release, so quote unquote fraudulent, frivolous, or otherwise non-meritorious family-based immigration visa petitions erode confidence in family-based pathways to lawful permanent resident status and undermine family unity in the United States. The thing that's undermining family unity in the United States is USCIS policy of slow walking and, basically scrutinizing cases without regard to actual content. It is an arbitrary and inconsistent methodology that they're using. That's why in one case that came to us at Silmi Law, we had an individual, U.S. citizen, who sponsored his elderly mother for a green card. And essentially, they were pending for more than 2 years. More than 2 years, the I-130 for a parent of a U.S. citizen was pending. And this dates back, obviously, before the current administration. What we did is we filed a writ of mandamus in this case. And that is a process, an administrative a process that we file in federal court suing the government for not completing the administrative process required. As soon as we filed the writ of mandamus, the USCIS issued its decision on the case. They happened to request additional evidence in this particular case, which we're happy to provide. The point is, we got them off their ass. We got them moving where previously they were just not responding at all to our client, not responding at all to the case. Once we filed a writ of mandamus, things change. And we will do that more often than not when a case is outside of normal processing time. I would use the term exceedingly outside of normal processing time, because if something is just a week or two or a month outside of normal processing time, it's probably not going to be efficient or, viable for us to sue in every single instance. And, you're not likely going to get a favorable outcome. But we do find that where cases are exceedingly outside of normal processing time, it is definitely appropriate to file a lawsuit in those cases. So, we have to make sure that things are done. The last thing I would note regarding the news is that, this is a kind of a interesting article we came across. So Uncle Sam to social media memes, inside Homeland Security's push to swell ICE ranks. So you might see these in your social media, but basically you have the Department of Homeland Security advertising that basically America has been, quote, invaded by criminals and predators, and we need you to get them out. This is about building up the ICE forces based on the most recent legislation. They're talking about an additional 10,000 ICE officers that would be hired to, essentially go into immigrant communities and make arrests of people for lacking the proper paperwork. So it's super important for everybody to make sure that you get that paperwork. Don't allow yourself to be put into a situation where you are, vulnerable, because that's going to be quite scary. So overall, I think that those of you who are in employment-based situation, you need to really get off your butt and talk to us about your EB1A petition, because the amount of scrutiny that is being put upon visa holders, like somebody that just has a H-1B, could be subject to a heightened level of scrutiny as it relates to their status with a lot of the executive orders and policies that are out there. So you definitely put yourself in a better situation when you're able to get that taken care of and move towards an actual, green card situation. So do reach out to us. We're happy to help. I hope this was helpful for you. Remember, it's for education purposes. And if you need an actual legal consultation, please reach out to us at silmilaw.com. We'd be most happy to help.